I'm not going to accept an agreement of 2 years. I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. Mr. Kimler, on Naomi Kidd. So I have that sentencing, but why'd y'all do new paperwork? I don't understand.
This is agreed. I just took count one.
I mean, he's already pled on 4, 5, 8, 9, and 13.
Okay.
Pled true before, and we got an updated pre-sentence report, and he wants to change his plea
It's fine,
on,
4, 5, whichever he's played true to.
what, am I on Naomi Kidd?
Yes.
Okay, well, this is one we have lost our file, so I had to get it recreated, so I just have the motion. Was there it looks like it was an amended motion? And somehow that file got lost, so I'm behind.
All right, so
That's
what we,
fine, if he's already pled, Judge, we'll just go with those counts.
so previously, Mr. Kidd was in court, entered pleas of true in a motion to revoke, or a motion to adjudicate, and pled true to, again, counts 4, 5, 8, 9, and 13. At that time, it was unagreed.
He subsequently received 117 months in the federal system, Your Honor, and we've reached an agreement.
Okay. So he has already been sentenced in the federal system to 117 months.
And it will run consecutively to this.
Okay.
That's why we're doing the low offer, just to clear this case, Judge.
And that's by court order of the federal judge.
Okay.
I've got a copy of that, Judge, if you can see it.
So he's on, I understand what y'all are, I understand what y'all are trying to do. However, I don't know that just getting rid of the case is what I think is appropriate. If he's on probation for robbery, placed on probation November 16th of 2022, and has now been sentenced, which means he either pled guilty or a jury found him guilty of new offenses while on this probation of Hobbs Act robbery, brandishing a firearm in a crime of violence, possession of a controlled substance with intent to distribute, and possession of a firearm in furtherance of a drug trafficking crime.
Your Honor, I'm not sure the offense dates of all that they made predate him being placed on probation.
They dismissed all the other charges.
What did you get 117 months on?
For the brandishing and the rob. The other charge was dismissed.
So the brandishing a firearm in a crime of violence. So brandishing a firearm in the robbery, but they just,
It's two charges, it's the same charge, but it's just two different charges. It's the same crime, just two different charges.
so the Hobbs Act robbery and the brandishing a firearm. Okay, and you got 117 months for those. Okay, I want to know offense date.
What was the offense? When was that arrest have been committed?
Do you have that?
I've got a judgment, but it says offense ended 2/19 of 25. I don't know if that means that was the offense date or if that was the date that he pled.
2/19 of 25 is the offense date, and I have he was taken into custody on February 25th of 25.
Does that sound right when it was committed? Right on.
February of last year is when you did it.
That's why I came to jail.
But when did
It was
you,
like January.
okay. So after you were already on this probation, this didn't happen a long time ago before you got this probation. You were on my, I want to make sure, you were on my probation
Just answer it. Well,
and you committed the new offense. I'm just trying to get the timeline
Yes, ma'am.
correct. Okay.
okay.
Then I'm I understand how,
The feds had already picked it up, you know, picked up the other charges.
you started my probation in 2022.
Yes, we could.
My question is, did the new robbery, the federal robbery, happen before 2022?
I was
No.
already on probation.
Right, okay. So I understand the moving of the case. He's already pled true to counts 4, 5, 8, 9, and 13. I think with the judgment, obviously, and the state could easily prove up the new, at least part of the new offense. I'm not going to accept an agreement of 2 years. I don't think that is appropriate. I understand that it runs consecutively, but it sounds to me like somebody who's on robbery, who commits another robbery, needs a little more time. So, I mean, 117 months is,
It's like almost 10 years.
yeah.
Do you want to get an updated pre-sentence?
I already
report?
did. I'm ready to sentence him
To
today.
reflect the federal, reflect the
I've already
facts of the
got it.
federal case.
I mean, no, I've already got an updated pre-sentence report. Y'all got a judgment saying he's got 117 months.
I didn't know if the court wanted to know the facts of the underlying federal charges.
If you want to tell me them in
I
a
don't-
hearing today,
all right.
here's the thing. It's already was unagreed. We're going forward unagreed. I'm deleting this paperwork. Let's go forward. I'll make a decision today on sentencing. And so let's start with Mr. Smith. Well, first, have you both had an opportunity to review that updated report?
Yes, sir.
I have not judged, but
You want to?
I
I'll hold the case. Go ahead. You good? Okay.
I think, okay.
Do you, so with regard to counts, let me look and see which count it actually was. It looks like, I mean, hold on. Okay. So it looks like after he pled on when we were here before, he pled on a first amended motion to revoke unadjudicated probation. And since then, another administrative hearing was filed. There is a second amended motion to revoke unadjudicated probation. Let's see what that included that this one did not. For the discussion and testimony today with regard to the fact that he has received 117 months on a federal offense of some combination of either Hobbs Act robbery or brandishing a firearm in a crime of violence, same offense.
both, was convicted on both of those. He received 33 months on count 1 and 84 months on count 2. So I would assume the 33 months would be the brandishing a firearm and the 84 months would have been a Hobbs Act robbery.
The firearm case would have been stacked.
And those are run
Those are stacked
stacked.
on top of each other and stacked on top of whatever the state gives.
Whatever this, so they knew over there that this was pending, and that judge already made the decision that this would run consecutively.
I spoke to his defense attorney in the federal system,
Okay.
Gary Bono, and I believe he said they deviated up based on the fact that this case was already pending.
Okay,
Departed.
It was taken into consideration in his federal sentence, and they went above what the guidelines said.
So there was an upward departure then because of the case being committed while he was on probation.
sounds like it.
I believe so.
Okay, Mr. Kimler, you may go forward with argument for sentencing.
Well, Your Honor, I suppose the salient factor here in sentencing is the commission of the charges that led to him being indicted federally. And I understand the court's reluctance to accept what amounts to a de minimis sentence on the state charges because of the 117-month state charges. I suppose I would simply observe if we've just determined that there was an upward departure in the sentencing guidelines in the federal system that was predicated on the pendency of these, of him committing the federal charges while on state probation for these charges. I know the court's probably inclined to go above the 2-year recommendation, but what the court stated previously, I would simply observe that he already has been somewhat sanctioned in the sentencing determination of the federal system because of the status on probation here in state court. These are going to run consecutively. And you may have gotten less time federally, but for the existence of this probation. So I would just ask the court consider that in determining what the proper sentence is in this revocation.
Thank you, Mr. Kimler. Mr. Smith?
Judge, I have quoted from it. I guess I would offer into evidence a certified copy of the federal judgment, which would allow the court to then find counts 14 and 15 in the second amended motion true.
Well,
No.
we didn't go through the second amended, so let me see. The first amended actually has the robbery.
That includes everything up through 13. So then the second amended was 14, 15, 16, and 17.
I have no objection to it being considered, the judgment being considered for sentencing purposes
Okay.
here, obviously.
And the first amended actually on count 11,
I believe
The
those were the
allegation is-
state charges, the same thing that were not filed with the state, but were picked up by the feds. And that's what
okay,
he was
but it's the
saying.
same offense, the
Same
robbery,
offenses.
February
Just
9th.
when we amended the second time, we included the
Okay.
federal
Same
charge.
factual predicate.
No objection to states one.
No objection.
All right, it's admitted. Anything else? Argument or
No,
thoughts?
state leaves it up to the court in this case.
So what I'm looking at is that there was also, and can't tell what happened with it, back in 2024, there was an unlawful carrying of a weapon by a felon.
They never moved forward on it because technically he was on deferred.
Deferred.
So he was not considered a felon. So they never, that was the original charge that was alleged in the original administrative hearing.
Okay.
But the DA ended up never filing on it. The subsequent charges are federal.
Gotcha.
And that's why they're in the second.
So there was at least an instance back in March of 2024 where the defendant was arrested and in possession of a firearm, but because he was not convicted, it was not filed.
Correct.
So we had that, administrative hearing was held. He already had completed both tracks of ISF and a motion was filed. And then he was absconder.
Correct.
And while he was absconding, picked up the new federal charges.
Yes.
Okay. All right, anything else? Anything else?
Is that accurate? Nothing else.
Okay, so then at this time, I am going to find, based on the evidence presented today, count 11 true in the first amended, which is the robbery. It's still the same offense, even though it was federal or county. It was committed here in Jefferson County on February 19th of 2025. Everyone's agreed to that. So I am finding count 11 true. And at this time, Mr. Kidd, I'm going to find sufficient evidence based on finding count 11 true, as well as your pleas of true to counts 4, 5, 8, 9, and 13 to find you guilty of the offense of robbery. I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This was not an agreement, so you do have some rights to appeal. I'm going to hand you that certification, if y'all will please sign it, Mr.
Yes, ma'am.
Kimler, and give him that bottom copy. Also, I'm going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. You need to sign that so you can get a copy of it, saying that you received a copy of that. Thank you. And did you